I'm going to talk briefly about what's happening at the state level in terms of changes to rules and regulation to facilitate access to care during the COVID-19 pandemic. I'll also be reviewing some interesting legal developments that are either directly responsive to the pandemic or playing out during the pandemic. So to begin, as Mona explained, the federal legislation and the way that California has operationalized some of the legislative changes have allowed for the creation of a new type of presumptive eligibility for Medicaid, which in California is referred to as MEDI-CAL. So if anybody in California is uninsured, or if they have private insurance that doesn't cover testing or treatment for COVID-19, then they do now qualify under this new category of presumptive eligibility under MEDI-CAL. This also allows, in addition to testing and treatment for COVID-19, for the 90-day supply of medication, similar to what we heard about under Medicare. In addition, disinfectant products and gloves are now treated as temporary covered pharmacy benefits, provided that a prescription is written by the provider. And also of note is that Covered California has extended their open enrollment period through the end of this month, June 30th of 2020. It's nice to know that all the presumptive eligibility channels, such as MEDI-CAL presumptive eligibility, are now accepting applications by telephone as opposed to strictly in writing in person. Next slide. Now I'm going to talk for a few minutes about some of the regulatory changes in specific topic areas, starting with sexual health. In California, we have a special publicly funded program called Family PACT, which is Family Planning, Access, Care, and Treatment, also known as FPACT. It's a carve-out of our MEDI-CAL program. And prior to the COVID emergency, Family PACT did authorize the use of telehealth for certain purposes. That has been expanded in response to COVID-19. Telehealth can now be used to enroll new applicants, to recertify existing participants, and for special types of consults and visits, which can be conducted over the phone or by video conference, using some of the less secure modalities that Mona mentioned before. So I just want to take a moment and step back and say, telehealth is not new to COVID-19. It's been much more broadly implemented and authorized. And prior to COVID-19, in order to use telehealth, providers had to use HIPAA compliant modalities, and there were special types of technologies developed. So various electronic health record or EHR systems would often build out a telehealth component, or certain other types of products like Zoom came out for Zoom for healthcare. So for specially designed technology platforms for virtual visits, whether on the phone or whether on video conference, that were authorized as compliant with HIPAA to ensure security and privacy protections. And the biggest change is that now we've relaxed those standards, and modalities that are not quite so secure are permitted to be used during the COVID-19 emergency. Another benefit under the Family PACT rules changes is that utilization limits on medication have been waived, and self-administered birth control shots, Depo-Provera, which gets usually inserted in the arm, those can be self-administered at home and covered by Family PACT so long as they're under the guidance of a provider. I do want to acknowledge one other critical change, which is prior to COVID, in order to utilize telehealth, there had to be a pre-existing relationship between the patient and the provider. So they had to have had at least one in-person visit before they could use telehealth that would be covered by Family PACT. Since COVID, however, that pre-existing patient-provider relationship is not required, which means that the first encounter that a patient has with their provider under Family PACT can be on telehealth platform and still be covered. You can also consent your patients on the phone. It no longer has to be done in writing and in person, at least for the duration of the pandemic. Next slide. The next area I'd like to talk about is the breast and cervical cancer arena, and similar to the changes with Family Pact, the Every Woman Counts and breast and cervical cancer treatment programs also are now allowing patients to enroll and recertify using telehealth instead of having to do so in person and in writing. It can be done on the phone. And primary care providers who are covered by Every Woman Counts or BCCTP are now authorized to use telehealth for delivering covered services where medically appropriate during the pandemic. Thank you. Next slide. There's also been some changes in the domestic violence space. The governor recently, as of just, I believe, May 29th, signed an executive order that achieves the following. The first is that the largest public funding source for domestic violence programs is called the Domestic Violence Assistance Program, or DVAP. And historically, prior to COVID-19, any agency that wanted to apply for DVAP funding had to demonstrate that they could provide a 10% match for any public funds that would be received. And the emergency order now waives that 10% match for domestic violence applicants for DVAP funding. There's also been an allocation of $3 million from the California Office of Emergency Services to domestic violence agencies to support their response to COVID-19. So as you can imagine, in any type of shelter where, which is an essential business, steps have to be taken to increase sanitation, to try and facilitate social distancing, which may be difficult in a confined space. And equipment and training may have to be purchased to facilitate telephonic or video conference-based service delivery. And so these funds can be spent on those types of expenses or even purchasing additional cleaning supplies and so on. The state is also partnering with several agencies to provide free transportation for domestic violence survivors through Uber, as well as free accommodations through Airbnb. I also want to mention that the Judicial Council, which is the state regulatory body that oversees the courts, has adopted some emergency orders for the COVID-19 emergency. They have extended emergency protective orders, which typically would be awarded to a domestic violence survivor for about 5 to 7 days. Those can now be extended to 30 days. The purpose, of course, is to minimize the number of times that an applicant has to go to court. And in a similar vein, these emergency protective orders can now be applied for using remotely using a platform like Zoom. This means that an applicant no longer has to come to court to apply in person. Next slide. Legal developments. So we've seen some interesting litigation surface during the COVID-19 pandemic, and there's also some very important Supreme Court cases that are being decided during the same time frame. So I'm going to start with a lawsuit, next slide, that was recently filed by the American College of Obstetricians and Gynecologists, ACOG, as well as several other medical associations, in tandem with several reproductive justice organizations like Sister Song. These organizations are challenging the FDA's rule that requires patients to go to a hospital, clinic, or private medical office to pick up a medication abortion pill. So in the United States, about 39% of all abortions are actually done using medication, and the medication at issue in this lawsuit is mifepristone. It's actually a combination of 2 pills that are taken, and prior to COVID, the FDA protocol actually allowed patients and providers to do the initial consult and any counseling related to medication abortion on the phone. And then the patient has to go and pick up the prescription in person, but then they can go home and take the pill. Literally, the act of swallowing the pill can take place outside of the supervision or presence, at least, of the healthcare provider who prescribed the pills. So interestingly, during the COVID-19 emergency, the FDA suspended this in-person pickup requirement for 18 of the 19 drugs that the FDA oversees. Of course, the only one that the FDA is still requiring patients to go and pick up in person is mifepristone. And so this lawsuit is intended to do away with that discriminatory treatment because it does interfere with patients' ability to access this legally provided medication. And if it's not being picked up in person, it can be delivered via mail through mail order pharmacy, or at least dispensed by telehealth. So that's the purpose of this litigation, and there are links to the bottom if you'd like to read the complaint or if you'd like to learn more about the case. Next slide. A number of states have taken the interesting, pretty clever step of issuing their public health emergency declarations to include abortions as non-essential or elective health procedures. In other words, they don't feel that time is of the essence when it comes to abortion. There's been a slew of litigation challenging these declarations, and as of today, there is one such state declaration that is still in effect, which effectively bans abortion during the COVID-19 pandemic, and that ban is still in effect in Arkansas. But the bans in all of the other states have been either blocked altogether by court order or at least temporarily suspended because of a settlement or some type of executive or government action. Next slide. So you can see that on the map here that most of the states in question that have taken this extraordinary step are in the South. The only state that still has an active ban in effect is Arkansas. Next slide. There are two interesting cases that are pending right now before the Supreme Court. The first is a case about abortion access. This case is called June Medical Services versus Russo. It actually used to be called June Medical Services versus G, but there's been a change in personnel at the Public Health Department from G to Russo. That's why it's a new name, in case you've been following the story. The Supreme Court held oral argument on this case on March 4th, and we will receive a decision from the Supreme Court by the end of this month, because that's actually when the term ends, June 30th. So all Supreme Court decisions have to be released by June 30th. It's now June 10th, so it's literally any day now. This case challenges a law in Louisiana that requires abortion providers to have admitting privileges at a hospital within 30 miles of their clinic. It may sound on the surface like an interesting idea, but actually in 2016, the Supreme Court struck down a law in Texas that was substantively identical to the Louisiana law that's in question right now in June Medical Services. And the court found that there's actually no reason to require hospital admitting privileges if the stated purpose is to protect women's health. These laws do nothing based on the medical evidence that was reviewed by the Supreme Court. These laws do nothing to actually protect or advance women's health. In fact, they do the opposite. They restrict access to abortion. The reality is, in conservative states, many hospitals refuse to provide admitting privileges, but this is all kind of a red herring because most, well, first of all, abortion is considered one of the safest medical procedures, and the complication rate is very rare, and even rarer for a complication that requires hospitalization. And in those cases, a patient can simply show up in the emergency room. They don't have to have a physician with admitting privileges. They will be seen, they will be treated at any emergency room at which they appear. At least they should be under the law. And so under the current jurisprudence or the legal philosophy of the Supreme Court, the threshold question is, does an abortion restriction passed by a state create an undue burden on a woman's constitutional right to access abortion? And in 2016, in the Supreme Court case, Whole Women's Health versus Hellerstedt, the court found that the Texas law, which is substantively identical to the Louisiana law, in fact created an undue burden and therefore was struck down as unconstitutional. There is another question that's at issue in this case, which is whether providers actually have standing, legal standing, to bring the lawsuit in the first place on behalf of their patients. And the court can decide either or both of these legal questions to dispose of the case, but really the larger question is whether this particular restriction constitutes an undue burden. Next slide. The second Supreme Court case is called Little Sisters of the Poor versus Pennsylvania, and there's actually a companion case, Trump versus Pennsylvania. These two cases have been consolidated. There was oral argument on both of these cases on May 6th, and a decision again will be released by June 30th. And this case is about contraceptive coverage. So the Trump administration recently enacted a new rule that exempts a wide range of employers from having to provide coverage in their health insurance plans for contraception. And the legal challenge is whether this exemption is constitutional or is it unconstitutionally overbroad. There's also some legal questions and challenges raised to the procedures by which the Trump administration passed this rule and whether the Trump administration violated the Administrative Procedures Act in the way that it passed the rule. That's more of a procedural question, but the substantive question really harkens back to the Affordable Care Act, which and actually Mona, my colleague, helped to draft this section of the Affordable Care Act. And the section in question requires most employer-sponsored health plans to include coverage for contraception in their health insurance plan for their employees. Now, even at the time this was introduced, back in the Obama administration, there was an exemption for religious institutions. So churches, temples, synagogues, mosques, religious institutions whose primary purpose is to inculcate religious faith. They were exempt from having to provide contraceptive coverage if that provision conflicted with their religious views. During the Obama administration, as this was implemented, there was a slew of litigation by different types of employers claiming that they should be exempt as well. And over the course of many years and some forced mediation from the Supreme Court, the Obama administration and many of the plaintiffs worked out several solutions, including an accommodation in which a religiously affiliated employer, so let's say a hospital that is religiously affiliated with a Catholic church, or maybe a school that is run by a religious organization. If these were religiously affiliated employers, that they could seek an accommodation and submit some paperwork to the federal government stating that they had a conflict with their religious views in providing this coverage. And then the federal government would take over from there and facilitate the provision of contraceptive coverage to employees of the religiously affiliated employer at no cost to that employer and actually no further involvement. So there was no administrative burden and no cost once the federal government took over. That wasn't enough, and we are now seeing another round of litigation. And in response, with the change in administration, the executive branch has now issued a whole new rule around contraceptive coverage, and that's where we are today. So the Trump administration's final rule exempts not only religious institutions and religiously affiliated institutions, but also any nonprofit employer, as well as any for-profit corporation that is not publicly traded from having to provide contraceptive coverage. That's a pretty wide range of employers, and that's the basis of the challenge. Is this exemption overbroad? So we are waiting to hear what the decision is going to be from the Supreme Court. I mention these two cases because they're pending at this time, and the court does not exist in a vacuum, and there's a lot of speculation as to whether the realities of the COVID-19 pandemic and how that has impacted access to reproductive health services, whether that will inform the court's decision. Nobody really knows, but I think it is important enough to acknowledge that these decisions have not been rendered yet, and yet the oral argument did reflect, and some of the questions did reflect the reality of the COVID-19 pandemic. So we will be keeping you posted on our website and our social media posts once these decisions are released. Next slide, please. So all of this is a very exciting review of the many important funding, legislative, and regulatory changes that have already happened to respond to the COVID-19 crisis. But it really begs a larger question, which is, what have we learned and what should we leverage for the long-term rebuilding that will follow this pandemic? So what are some of the issues and learnings that should inform our future policy and advocacy efforts moving forward? Because we have seen how effectively this pandemic has highlighted the deeply entrenched inequities in our health system in this country, and how communities of color, low-income communities, the immigrant population, LGBTQ individuals, and women have experienced negative health outcomes due to these long-time institutional barriers and disparities in care. So how can we address those moving forward as we rebuild post-COVID-19? So the top of line question is, which of these responses, whether funding, legislation, or regulatory, that are currently temporary, should we push to make permanent? Some of the things that are on the table are the availability or authorization for remote consent, the ability to enroll and recertify applicants by telehealth or over the phone, this notion of parity in reimbursement for telehealth, meaning that providers should be paid the same regardless of whether they are delivering care in person or on telehealth. Even the question of relaxing the privacy protections, I think, is going to be up for debate. We also are looking to how do we protect the safety net moving forward, especially in light of our massive state deficit. And we're really interested in hearing what you're thinking about. What are your organizations working on, or what's your dream wish list in terms of policy items moving forward? And you are welcome to chat your ideas to us. We also have included a question in the evaluation survey where you can submit your ideas. Next slide, please. Finally, we've just compiled on this one slide the resources if you'd like to learn more. Obviously, most of our slides have sources at the bottom, but these are kind of higher level across the board if you'd like to learn about what are the new telehealth coverage policies, how are Medicare and MEDI-CAL responding to COVID-19, and some of the specific state programs like Every Woman Counts and Family Pact, as well as where you can find more information, including commentary, as well as all of the pleadings for the Supreme Court cases that I mentioned earlier. Next slide. This is our contact information if you'd like to contact us.